Marcy.
Good morning. My picture's back.
I love your picture. Good morning, everybody. Welcome to Monday morning. It's time to get up and get working again and make our businesses work for ourselves. Today, we are going to talk about wills or powers of attorney and how they work, what it does for you, and then the notarization aspect of them. Okay, so the first thing I want to talk about is, what is a power of attorney and should you have one? So a power of attorney, whether it's for healthcare or financial, they call it durable power of attorney, which the durable power of attorney handles everything but healthcare, basically. But you have choices on what you want the people to be able to take care of. So most of the powers of attorney that you are doing yourself are going to be, they'll print out a form and you'll check yes or no on each one. Like you'll initial next to the things you are approving your agent, that's what that's called, to take care of for you. So they'll have everything from like handling your health insurance to handling your bank accounts to writing checks for you and lots of things financially that would need to happen. Maybe it's taking care of your children or, whatever that looks like. So a healthcare power of attorney is just that. It's only healthcare. And within that power of attorney, you have the option of making choices so that the person who accepts agency, and that's the person you're giving power of attorney to, that person can, I'm lights off, sorry. The person you're giving agency to act on your behalf should use what you want as their guideline on how to handle things when you are at your end of life. It's not when you get in a car accident and they go, oh yeah, just pull the plug. That's not it. That's not how a power of attorney works. And a power of attorney, no matter what kind it is, ceases to be effective when you die. Okay, when the person giving power of attorney dies, powers of attorney no longer are in effect. Okay, that's where the will and the trust come in. A lot of people get this mixed up. I have had several people call me. They wanted me to come and do sign a power of attorney for them, notarize a power of attorney, because their family member is dying. Okay, it doesn't do them any good, but they didn't understand that. But we can't give legal advice. So how do you handle that, right? You handle it by, if the person is dying, if they're in active dying stages, they can't sign anything legally anyway. If they're on medications, they can't. So you have to do the cognitive test. So sometimes, and I've had people call and say, she's dying. The doctor says she's dying and she has to sign this power of attorney. So I ask, what do you want the power of attorney for? So I can handle her finances after she dies. Okay. I do tell them, I'm sorry, I do say this, have you looked up what a power of attorney is? If you look it up, you find. So if you can state facts and or point them to the direction of what the facts are or where they can find that, you're not giving legal advice. You are saying on this website, it says that a power of attorney ceases to be in effect when a person dies. Powers of attorney are only effective when people are alive, not when they're dead. So you have to get creative in how you let them know this, but also you can go knowing that you're not going to be able to charge them for this, because if you don't notarize, you can't charge. You might be able to still collect your travel fee. That's between you and them. And I don't charge a travel fee. I don't charge anything if I go there and I can't sign. I just don't. I'm not. We are for the people. And to me, that's just cruel. So I just don't. So I have gone to places and the people were unable to sign, and I just have to gently let them know that because he's on medication or because he can't answer me, I can't notarize his signature. And people are visibly upset, and you have to be, kind to them, and you have to show some compassion, but then you're sorry. But then you need to have a lawyer in your back pocket. You need to have an attorney like in your phone, and you can say, call this attorney. Maybe he can help you, or maybe she can help you. Instead of you trying to help them or leave them hanging, you say, here's an attorney's name and number. Call them. Maybe they can help you. Because let them do the legal work. Let them do the stuff that you can't do, even though you might know better. So we also want to look at what a power of attorney looks like. So what I did was I got a whole bunch of power of attorneys. Tell me, Deb, can you see power of attorney on the screen, or do you see Will? Power of attorney. Okay. All right. So this is a power of attorney. I have a few of them, and I've redacted a few powers of attorney, or like 4 of them, and then a will. So this is a durable power of attorney. And this actually is for the financial side and for the anything but healthcare side. So this attorney, I'm going to scroll through. I'm not going to give you guys a copy of this. I just want you to see what it kind of looks like all the way through. It's several pages. It's 20 pages long. The last 2 or 3 might be accepting agency. We'll talk about that when we get to it. But you see there's check marks. Can you operate my business for me? Can you?
Is that supposed to be initials, not check marks?
Yes. Oh, I'm sorry. Yes. Thank you. It is where they would have to initial that you can handle the banks or other financial institutions. You can handle the operation of my business. You can handle my insurance and annuities. You can handle my estate, my other beneficial interests, things like that. Claims, litigation, if you go to court, personal and family maintenance, like to take care of the kids, or, to give money for the kids, the benefits from government or civil or military service. So they have a lot of things they need to think about when they're putting a power of attorney together. Their retirement plans. Typically, it's a spouse giving power of attorney to their spouse, but there's a lot of people who aren't married, and they will give it to one of their children to take care of. Sometimes it's an attorney to take care of, but instead of doing initialing each of these, this is all preceding subjects. So we aren't going through this with the client, because that's giving legal advice. It's reviewing a legal document, which we can't do. The attorney, this is an attorney prepared power of attorney. The attorney goes through it, and then I come in afterwards, or they've already gone through it with their attorney. They've already made their decisions. So then when I arrive, all I have to do is say, initial here, the ones that you do. If I know that they've already chosen all preceding subjects, they initial all preceding subjects. Okay. Okay. Reliance on this power of attorney. This is where the signer, the person giving power of attorney to whomever, signs here. This is an example of when witnesses get sworn in. So Debbie, you actually did this one. Did you act as a witness and a notary on this, or did you have 2 different witnesses?
I had 2 different witnesses.
And can you tell everybody why you had 2 different witnesses?
Because I had to swear them in, and then I am notarizing the signature. So in that case, I cannot give myself an oath, and I cannot notarize my own signature as a notary.
Yep. So when somebody says, do I need witnesses? Do I need 2 witnesses? What do I need? You have to find out what the signature page looks like. That's going to be your question when somebody says, I need a power of attorney. You can't just automatically assume you know, because you might not know. And this was a surprise to me and to Debbie, that the witnesses had to get sworn in. This was prepared by an attorney, and he has the witnesses being sworn in, but the signer is not.
Yeah, it caught me off guard.
It's a little bit different. Yeah. And then in the notary block, it also lists the witnesses right here. So Debbie could not act as a witness and a notary on this document. Okay. Let me see. Nope. This is hard to do because its stupid thing is in the way, the bar at the top. All right. This one was prepared by a different attorney. And this is the same. It's still a power of attorney for durable. And this attorney is a little bit more thorough. And they actually go through, remember over here, we had all those choices to make, or the client had all these choices to make here. This attorney does it differently. They actually go through line by line and prepare the power of attorney specifically for them. So anything these people are not agreeing to, they've removed. And so you see they don't have any signature, no, nothing says
Initial.
all preceding subjects to be initialed. It's all there. They've already agreed to all of these things. This is what they want. Personally, I like this better. Not that it makes any difference for anything, but I like it better because nobody can forge a signature on a line, you know, like if somebody felt that way, they wanted to do it. So it's all already there. They already know all the things. They've rewritten the will to include only the things the people said they wanted. Look at college savings accounts, retirement plans, lots of things in here, taxes, digital assets. So they are this attorney is very, very thorough. And then we get to the signature page, you know, whenever we get there, should be coming up. Okay, reliance on this power of attorney. Signature and acknowledgement. So the client is signing, and then the witnesses sign here, but the notary is not notarizing the witness's signature. Therefore, the notary can act as a witness and a notary on this document. So that's why it's super important to know what that signature page says. So when I get a phone call for somebody that says I need powers of attorney, I ask them to pull out that signature page and read to me everything from state of Michigan down to the notary signature, because then I can find out if it says witnesses in the notary block. So if you're not asking that, it's a really good idea to ask that. Debbie.
Okay. So I just want to make sure that everybody, because we have some new folks on here, can you go back to the first one? I want to show the difference between the two notary blocks. Where one specifically states the witnesses in the notarial block. And then, okay, so this one states, can you highlight where it says signer and then blank and blank? So that's signer and witness 1 and witness 2. This is your notarial block. This is where you have to input the names of whoever the witnesses were. You see the witnesses above. So in this case, because the witnesses are listed in the notarial block, the notary cannot be a witness because the names of those witnesses are actually in the notarial block, and the notary cannot witness or cannot notarize their own signature. Now skip down to the other one. Did everybody get that? Let me open up my view. Does everybody understand that?
Hey Deb, I have a question. This is Angela.
Uh-huh.
And so in the notary block, the signer, when it says signer, that means witness at any time.
No, the signer is the person whose document it is. We just redacted it to say signer in this case.
Oh, okay.
So that signer would actually be Mary. Yeah, it would be like Jane Doe as the signer, and then Leslie Hocker and Debbie Lowry, personally known to me or provided on the basis of satisfactory. So those are your witnesses. So signer is the one who is giving the power of attorney, signing the document, and then the witnesses are witnessing the signer sign this document.
Okay.
Do the witnesses
I was a little confused on that because I know I've never had one like this that had the witness the witness in this, in the notarial block. So that's what I was kind of confused when it said
Yep.
signer. I'm like, I thought the signer was the actual, client.
The signer is the actual client.
Okay, I just got confused. Okay.
Under the witness, do they have to sign their name or is it printed?
So on this one, it doesn't ask the signer or the witnesses to print their name,
Okay.
but it's a good idea to have them do that. Because if this ends up in court, which it shouldn't with two witnesses and a notary, it shouldn't, it'll stand up in court, I'm sure, if it goes. But if it ends up where you have to go to court because of anything you signed and you don't remember who that witness was, and they didn't print their name and they sign with some weird signature, you're not going to be able to remember who that is. Because typically people are signing powers of attorney well in advance of them needing to be used. So if I have a power of attorney done for me and nobody needs to use it for 8 to 10 to 30 years, who's going to remember who that witness is? So it is a good idea to print it. You'll notice over here, it is printed on the other attorney. This is where the signature goes. And this is where they print their name. And they also print their name here. So it's print, sign, print. If you ever go with me, print, sign, print, sign, print, but only on 2 of them. But that's comes back to these witnesses are not listed in the notary block. Notice that?
Yep.
But over here, they are. When they're here, you cannot act as a witness. When they're not here, you can. That's how you know the difference. Does anybody have any questions on that? Okay, good. All right, let's move on to the healthcare power of attorney. So then they have patient advocates and they're going to name those people. Okay, that's what these blanks are for. They name who it is. They name special instructions regarding the care they do want and the care they don't want. Now, this is the way one attorney does it. You're going to see it different from the other one. But they're going to see, I don't like this because I don't know what kind of care might be a choice. So you might say, I don't want to be resuscitated, but it's all regarding life-sustaining treatments. And then they're having these people sign it over and over and over again. Choices, choices, choices. But then they sign and the witnesses sign and they print their name and they date. And then the patient advocate, there's always the signature of a patient advocate. And these are the people that they're saying will speak on your behalf. That's what this attorney calls it, a patient advocate. We go over here and this attorney has you do it this way. Initial, I elect to grant my agent notice in the other one was advocate, and in this one it's agent. But either way, they have to sign to accept to be the advocate or the agent. Okay, so I elect to grant my agent the authority to make any and all decisions covered under option 2. This is option 2. And this is where they can say, I don't want CPR. I don't want mechanical respiration. I don't want tube hydration. I don't want tube nutrition. I don't want antibiotics. I do want maximum pain relief, even if it may hasten my death. Apparently, if you give somebody too much morphine, they can die. I don't know. I'm not in that field. But if they are going to initial anything on option 2, they have to initial option 1. And then it moves on to them saying, yep, I said that. Then they have to sign there. And then it goes on to the end where they're signing it, saying, yes, I want this. Okay. And then the
screen
witness
needs to slow down. You're talking faster than your screen is populating. Okay.
Oh, okay.
We're
All
caught
right.
up. We're caught up.
So, all right. So they have to sign twice. So they're initialing back there. They're signing twice. And then the witness is signed. So this is a healthcare power of attorney that's prepared by an attorney. So it doesn't need to be notarized. And then agents have to accept it, just like in the other one, the agents accept wait, where did it go? They accept agency or advocacy. They have to sign that. Otherwise, they can't do it. Okay. And then, okay, so does anybody have any questions about healthcare power of attorney?
Where did you get this one from? Because I actually, on the internet, I can't remember what site it was, but it broke it down just like this. And then I've run into one where it was sort of, I like this because it just goes through everything and you can pick what you want. But my other question is, I know we don't supply the form, but can, if say like the client calls and they ask if we could, and I'm not able to, can I suggest a couple of sites that can go and print it out themselves?
Yeah. Okay. So the answer to your first question is this one you're looking at now is prepared by an attorney that I do a lot of work for. Okay. So I just redacted one of their documents. The other one, your other question, yes, true. You cannot prepare documents for them. You can say there are a lot of places online and you can suggest eForms, Law Depot. There's a lot of places where they can get it. I will point them to an attorney because some people want to not spend any money. They don't have the money to spend it. I get that. But so I'll give them options like I have, and I'll put it in the chat, that one of my attorneys has that is very inexpensive and it covers it, and it's going to end up looking like this one, like the first one I did, because it's his company. This is actually from that, I just put in the chat, Guider, GUIDR.com. These two powers of attorney, the first ones, if you see at the top, MPS, CCS, healthcare, and POA, those are both from guider.com. So you go there, they're $79 a piece. It's very affordable. It's also prepared by an attorney. So it's all, but that's what you get when you do those. Okay. Lisa, you have a question?
Lisa's hand is up. Yeah.
I was just going to share that I recently had these done for myself. I went through Legal Shield, and what they did is gave me a questionnaire with all of those questions. Then the document they sent was more specific, and I didn't have to go check all of those dots. So it was a very small document because of that. So I wanted to share that.
Yeah, right. So that's another option for you, Legal Shield.
Yeah.
And some people,
and
I don't
Legal
know.
Zoom too. There's Legal Zoom.
And Legal Zoom. So they can really just Google power of attorney and come up with a bunch of them. And I'll show you, we're going to go to the internet here in a minute, and I'll show you the other things that we're going to talk about. I want to get to the wills real quick. Last will and testament. This is where, if you saw my little tease yesterday, about if you don't know what self-proving is, you need to be here today. So if you prepare a will yourself or a power of attorney yourself, that's called self-proving. You're signing it saying that you prepared it. And self-proven wills need to be notarized. But wills that are created by a third party, namely an attorney, only need to be witnessed. So I brought this one up just to show you how it looks when it's prepared by an attorney. And this is a document that I sign all the time, which is why I put notary here, because the notary can be a witness on this because there's no notary block. This is the end of it. So the testatrix, which I think is a woman, I don't know what that means, but this document was for a woman. She signed her name to this will, which was already prepared and already they went through everything. She signed it. They always put my name there because I'm the notary and I'm going to be there taking this document to them. And then whoever witnesses with us, then I sign here and my name is written here. And then the witness has to sign their name and print their name. And that is because it's made by an attorney. Okay. So when it's not made by an attorney, it's called self-proving. So I have to stop share and go to the other tab I have open
While
here.
you look that up, is is a third party, is that LegalZoom or Legal Shield, or is that still
Yes.
considered self-proving?
I do not know the answer. I don't have that answer.
I do, because Legal Shield and Legal Zoom, what they do is put you in touch with a lawyer, and the lawyer
Okay.
puts it together for you. I was also going to point out for my own clarification that you just witnessed the will. You did not notarize it.
Exactly.
Yeah.
Because it is not self-proving. When an attorney prepares a will, it does not need to be notarized. When a will is self-proving, hold on, we're going to go right here. This is wills. If you look up here, what is a self-proving affidavit? When you have put the will together yourself, it's called self-proving. A self-proving affidavit is a notarized document that helps prove a will's validity and speed up the probate process. It's signed by the will writer, the testator, and two witnesses who confirm under oath that they saw the testator sign it without any undue influence. That's what I mean by self-proving. Okay, so the key takeaways here, including an affidavit of witnesses with your will, can make it self-proved. Self-proving wills can pass through the probate faster since the court doesn't need to find the witnesses, you see. And a self-proving affidavit must be signed and notarized in order to work, but they may not be necessary in a few states. It is in Michigan. I can attest to that because I've taken the tests for this. And so in Michigan, I do know that if a lawyer did not prepare your document, it does need to be notarized and witnessed by two people. Okay. I think that's the same one. Here we have here. The statutory will is a form created by Michigan law. When the form is properly filled out and executed, which is signed by you and two witnesses, it becomes a valid will. The form has a fill in the blanks. That's at Michigan Legal Help. This limits how you distribute the property using statutory and some advantages. It's signed by you and two witnesses, and because it's legal help, I am assuming what Lisa said, this is where this comes in. Legal help, a lawyer prepares it, and you actually don't have to have it notarized. Look, here you go. I would always use a lawyer if I were you. What happens after my death? Anyone who has a copy of your will must deliver it to probate court where you lived. Did you know that? I did not know that. Like I just learned that this morning. I mean, I'm not dead, and I've never had anybody's will in my hand, so I guess I wouldn't have known that. So I guess this is how we learn, right? Some people do deposit their will with probate court for safekeeping, and then they open the file and your will when somebody brings proof of your death, like a death certificate. If you have a child under 18, when you die, their surviving parent, if any, will likely assume full custody. If your child's other parent died, had their parental rights terminated, or is unable to care for your child, the guardian you choose in your will can accept guardianship by filing with the probate court. The property you own at the time of your death is called your estate. So there you go. That's what an estate is. The process of distributing your property and paying your outstanding bills is known as estate administration. There are different ways an estate can be administered. If the estate is small, worth $25,000 or less, your friends or family may be able to use a simplified process where the probate court is not involved at all or only a little bit. The small estate processes ignore the wishes in your will. Nice. Instead, the legal formula of inheritance is used to divide the property. If your estate doesn't qualify for a simplified process, or if your heirs want to follow your will instead, the estate will be distributed using probate proceedings. Probate proceedings can be formal or informal and can take years. I'm telling you, years.
And cost money.
Right. This site is driving me crazy with all the things. So this is, must I have my will notarized in Michigan for it to be legal? A will must be signed by the testator or the person who made the will, and at least two witnesses who saw the testator sign. Notarization is not required in Michigan, but a notarized will may be accepted as self-proving potentially making probate proceedings easier for those you leave behind. So it just makes sense, doesn't it, to have your self-proven will notarized. In Michigan, a will must be in writing and signed by the testator and 2 witnesses in order to be valid, according to Michigan compiled law section 72502. In the case of holographic wills or wills written entirely in the testator's own handwriting, no witnesses are required to sign, but the testator must still sign the will. A will that contains only the signatures of the testator and witnesses must be proved in probate court, usually through asking the witnesses to testify that they witnessed the signing of the will. Self-proving wills, wills that contain the signature of the testator and at least 2 witnesses and are also notarized, are known as self-proving wills, according to Michigan compiled laws, section 700.2504. In order to be self-proving, the will must contain all the required signatures. It must also contain a signed and sworn statement from the testator and each witness that she has testified under oath that the document is the testator's last will and testament, and that in the case of witnesses, they saw the testator sign it. The notary then notarizes these sworn statements, which become part of the will. The specific wording of these written statements is given in the compiled laws, section 72504. The notary must be a separate person from the 2 witnesses in order for the self-proving will to be valid according to the Calhoun County courts. That is Calhoun County in Michigan? I don't think so. I think that's California. It must be in Michigan. This is a whole Michigan
There is
thing.
a Calhoun County. In
Yeah,
Michigan.
There is one there, but
Okay.
that statement is no longer correct as long as they're not notarizing their own signature. So there was a point in time when the notary could not be the witness and the notary. This was probably from then. However, there is a theory that some attorneys have that everybody does their job. So if you're a witness, you are a witness. If you're a notary, you are a notary. So some people, and I've actually heard notaries say the same thing. I'm not going to act as both. I have a job. My job is to notarize. That's up to you. It is legal, even though right here it says you can't. It changed. It just changed, and they didn't update the website. Nothing bad about them. The benefit of taking the extra step to have your will notarized in Michigan is that once the sworn statements are signed and notarized, no additional evidence is required before the probate court will accept your will, that your will is genuine. A self-proving will saves your personal representative and any beneficiaries from the trouble of tracking down the witnesses to your will and avoids the problem of what to do if the witnesses are no longer alive, according to the Calhoun County courts. All right, so thank you, Calhoun County, for taking care of that. That's awesome for somebody putting it out there because it's so hard to find. I actually looked for about an hour to find all that stuff. So, all right. So do we have any questions regarding these wills or powers of attorney or the notarization of such?
What's a good way to get that out there so we can maybe start doing them, just going to like some of the nursing homes or senior places and talk to the social worker?
So yes, I have found great luck by visiting the senior living facilities. I don't just send my cards. I visit there, I talk to the people at the front desk, and then I ask them if they're ever asked if they need a notary or if they have a notary. That's been the way to make it happen the easiest. Other than that, it's been networking, but sending flyers doesn't do a thing. It's gotten me 0. Calling doesn't do anything, mainly because they want to see your face. Okay. They want to see who it is they're letting into their building. I went to a senior living facility one day, got called, and I've told this story before, but I got called there, and the people that I notarized for in their room, and it was not it wasn't a hospital type. It was just they couldn't live in their house anymore, whatever reason. They lived in this apartment building for seniors. And the woman said, please drop your cards off at the front desk, because it took me a long time to find a notary. I didn't even know, there were mobile notaries. And so I went to the front desk and I dropped my cards off, and the woman thanked me for doing that, because there had been a man come in a day or so earlier, and she said he was very creepy looking, and there's no way I'm letting him in the room of my residence. So his cards went right in the trash. So you do have to look apart. You have to look like you're trustworthy. I don't know who the man was. I have absolutely no idea who it was, and I kind of feel bad for him, because he's probably a nice person. But if you go in there, looking deranged, they're not going to call you. They're not going to suggest their people call you. So, we are facing customers, and we should actually, look nice. I don't know what he was wearing, what he looked like. I know nothing about him, but he was a notary apparently. And he was looking for work. So that's how I found the best way when we're doing those. I probably go to a nursing home or senior living facility of some sort. I don't know,
Okay.
anywhere between 3 and 5 times a week. So it's not big money. And when you go there, it's, usually 2 signatures. So it's $20 for that, plus your travel fee, plus you have to take a witness with you. I don't mind doing it. I do it all the time, but you have to decide, is that what you want to go after?
Right.
It is, for me, it's all about quantity and quality. So quantity first. I'm not going to do a whole bunch of, I'm not going to go after one job and do 100 of them and then not do anything for a week, because I won't leave the house for less than $100. That doesn't make any sense. Debbie.
When you get called to do a POA at a hospital, you should always ask the people, do you need me to print the documents? Because what will happen is they will have the documents coming via email from a lawyer or LegalZoom or wherever they're getting them, but they have no means when they're in a hospital to print those documents. The hospital's not going to print them for you. So you're doing an enhanced service. I mean, I guess you could charge them for the, printing out the paper, but usually they'll give you a tip because they're so relieved. They've been trying to call a FedEx or a UPS, where can I get this printed? And you're like taking that burden off of their shoulders. So just keep that in mind. If you ever get called to do any kind of job in a hospital, ask if you need the paperwork printed.
Also, if you are going to a hospital or a nursing home or a senior living facility and they need witnesses, what you'll hear is, oh, I'm sure someone here will witness. I can guarantee you they're not going to, unless they're a new employee. They're not allowed to. Employees are not allowed to be a witness on any powers of attorney. And it's not that they're trying to form a hardship for anybody. It is that if this goes to court, they're not going to get a day off to go sit in court to say, yes, I watched them sign it. Because that could be a whole day of work that they miss out on, and they're not going to get reimbursed for. And that's why the policies say you can't. They don't want to lose a nurse for a day simply because she signed a piece of paper 7 years ago. Okay. Peggy.
My question is, so when you take a witness with you, do you pay the witness or do the client pay the witness?
Well, the client pays me and I pay the witness.
Okay.
And I charge $25. Now, all of the fees that you're going to charge these people, they have to know them up front. You cannot walk in there blindly and then say, oh, you owe me $150. So by law, and it is part of the Michigan law, that is that you have to let the client know how much they're charging, or you are charging them, before you leave. So there's no surprise fees. So this is how I do it. I say it is $10 per my notarization. You guys can sign as many times as you want, plus a travel fee. My travel fee is whatever, because I already know where they're at. So I tell them what my travel fee is, which might be $25, might be $30, might be $15. It depends on where they are. And then I say, and it's $25 for each of my witnesses. So if the notarial block is written so that I'm not notarizing my own signature, you'll save money because I'm not going to charge them as a witness and as a notary. That to me is very unfair, but I know of people who do it. I'm just not out there to take everybody's money. We're in this is a service field, and you get more business by not overcharging people. So I don't. If you do, that's fine. I just don't do that. So I will tell them. So it sounds like you need 2 powers of attorney, and I need to bring 1 witness with me. So that will be $20 for the notarizations. It's a $25 travel fee and $25 for my my witness. So I will add that up, which I think is $70. Thank you. And they're fine with that. And then I roll right into, you can pay me cash, Venmo, PayPal, whatever you would like. And they say, I don't have it. I have a check. We'll discuss a check. I will take a check if it's over $50. I do not take credit cards. They can connect their credit cards to Venmo or PayPal, and they can pay the fees. I don't do that. I will take Venmo or PayPal. I don't have a Square thing. None of that. Okay. But again, Michigan state law says everything has to be, they have to know how much they're paying before you start traveling. Now you can charge if you feel that you want to charge them to print their documents. That's fine. Be fair about it. It doesn't cost you $20 to print documents. It costs you, like, I've done the math. I think it's 13 cents a page. So what I charge, I'll charge them $5, but that also includes dropping the documents off somewhere if they need to be dropped off. So that's how I do it. Does that answer your question, Peggy?
It does. Thank you.
You're welcome.
All
Debbie.
right, I got 2 comments. The first, going back to when you're in a hospital. So the employees can't be a witness, but other people in the hospital could. So I've been in the hospital to do POA signings, and it might be the husband or the visitor of someone else in like the next room. So you can find, I mean, it is possible. They have to do their legwork to find someone if it's going to be somebody in the hospital. And
Okay, before you go on,
Yep.
the reason I caution against that is because you're going to be asked to find your witnesses when this goes to court. And if you can't find your witnesses because you just use some random person who was outside the hotel or in, the room next to you, that's going to be a problem. So if all they're signing is their name and they're printing their name and you have no idea where to find them again, that could cause a problem if it goes to court.
so do you not put your witnesses in your journal? I put my witnesses in my journal.
I don't have a spot for that, and Michigan doesn't require it, but I do keep it in my spreadsheet, but I don't identify them. So unless they're credible witnesses have to go in the journal, but signature witnesses don't. So no, I don't, but I take witnesses with me that I know personally. I have a W-9 for all of my witnesses. So I know where to find my witnesses. It's not an issue. So I don't run into that, but that solves the problem that I created by not knowing how to find them, right? Because you're actually putting them into your journal. That makes sense.
Yep.
Okay.
And I look at their ID, I write down there, I fill in that whole, I don't, sometimes I'll make them sign. That way I know, you're, and I put witness of POA for who, whatever, and have them sign. So they're in my journal so I can find them.
That's a really good idea. Thank you. All right.
And I forgot my other thing I was going to say. So please continue.
Darn it.
You mentioned something about a credible witness and a signature witness. Can you explain the difference in the two?
Sure. So a signature witness watches somebody sign. A credible witness is used to identify the signer. So let's say you, Peggy, called Debbie and needed something notarized. Okay. And Debbie goes and finds out that she does her due diligence on the phone and finds out that you don't have any proper identification. Like you don't have a driver's license, you don't have a state ID, you don't have a passport, you have nothing that is government issued to tell her who you are. So then the two of you would need to sit down and figure out if there's anybody that both of you know. Facebook is a really good way to do that. Like if you have mutual friends, you can usually use that mutual friend as a credible witness. So they're saying, yeah, Debbie, I've known Peggy for years and she is, whoever, and tells Debbie something that makes her believe that then you have to list the credible witness in your journal and they have to sign also.
Okay, thank you.
You're welcome. You're
Yep.
welcome.
And now I
And
remember what the
that
other thing
happens
was.
Sometimes. Go before you forget again.
In the, I know, getting old. In the POA, the one that we were looking at, the one that I did, it actually said the witness in the declaration, like, I don't work for a hospital. I'm not from the insurance company. Like, I had to state that. So make sure you read that witness block because it was all spelled out very clearly what they couldn't be. They couldn't be an heir. Yeah.
Okay. Was that part of the oath that you gave them, that they were attesting to that?
Yes. Yes.
Okay.
Yeah.
All right.
Yep.
So they need to read it before they sign it.
They should, yes. But I asked them all the questions before, and
Okay.
I did this one on online. So as it was, I couldn't see the witness screen because I just sent them the email, but on my screen, I just read it to them prior to them executing online.
Okay, got it. All right. All right. Well, that was very informative. Thank you. Does anybody have any other questions before we stop the recording?
This was good. Thank you, Leslie, because
You're welcome.
this is something that notaries can kind of pick up and roll with. It's not like loan signings where you need to know, the detail, what each kind of document is. This is something you can just start advertising. Facebook, your Google My Business page, put it out there. You need a POA. And so the jobs will come to you.
Yeah. Oh, Jenny Lynn has a question before we go.
Yep.
Jenny Lynn, go ahead.
I just remembered, you mentioned that if the POA is prepared by an attorney, it doesn't have to be notarized. Is that how it is for every POA?
No, only for the healthcare. The financial powers of attorney always have to be notarized and witnessed. So before we go, there are some hospitals, or I don't know, I stopped paying attention when I walked in the doors, that they offer a power of attorney a POA at the facility for people to fill out. And I often get called to notarize them, and there's no notarial block on those. So I don't know if they're being accepted without a notarial block. I don't know anything about those, except that there isn't one, and I just add a loose acknowledgement or a loose jurat, their choice, when that happens. So if you get called to a facility and they hand you one, and I think it's Henry Ford, now that I think about it. The last one that I did, the people were being transferred from Henry Ford to a Beaumont, which now has a new name. And they wanted to know if it was going to be accepted there. I have no idea. And I can't tell you that if it is, because that's legal advice. So we have to stay in our lane when we're notarizing, but we also have to know things. So you can't go in ignorant of these things, but you also can't you can't give them all the information that they're asking for. Unfortunately, that's why you need to have an attorney in your back pocket so that you can refer them to an attorney. Most attorneys will answer 2 questions, at no charge, but they're not going to prepare a whole plan or even a power of attorney for you for free. So they might answer that, can I take this from one facility to another and have it be accepted? Which the answer is probably up to the other facility if they're going to accept it or not. And it's probably not up to the law at all. I don't have any idea, but just know that sometimes that happens, that sometimes people do call you to notarize things that don't have a notarial block. So you do need to have jurats and acknowledgements with you and you need to ask them which one they prefer. And you can say, you know, I need to add a notarial block to this power of attorney. This is a jurat, this is an acknowledgement. The acknowledgement says, I watched you sign. The jurat says that you are attesting that the contents of the document are true. Which one would you like? And they make the decision, and then you go forth from there. So, all right. Well, thank you all for attending. This was a wonderful session, very informative. Please join us on Wednesday night. We're going to be back here, and we're going to be talking about some other wonderful things, notary conduct and ethics, which is kind of goes off of this, but thank you.